കൊടുക്കല്ലേ സ്റ്റോപ്പ് തന്നെ കൊടുക്കല്ലേ.
Good evening to one and all. Today we have the sixth session of our continuing legal education program post 2022. Today we have a prolific speaker among us, Senior Advocate Dr. Aditya Sondhi. I'd like to invite Senior Advocate Dr. Aditya Sondhi onto the dais, along with our President Rajesh Vijay, our Secretary Sri K. Anand, and our Vice President Sri Santosh Peter. I request our President Sri Rajesh Vijay to welcome the gathering.
Good evening. Dr. Aditya Sondhi needs no introduction before lawyers. You might have watched n number of lectures on YouTube. Still, for some people who is not familiar with him, I'll speak a few words. Dr. Aditya Sondhi is a product of National Law School, Bangalore. After that, he took a MA in politics and PhD from Mysore University for his research on a fantastic topic, the interface between the army and democracy, India and Pakistan compared. He is a speaker and has lectured across the country and also abroad. He has published twice with Penguin books. His books Unfinished Symphony and The Order of the Crust trace the history of his old school, Bishop Courtney's. Aditya, interestingly, an actor in plays, on stage actor, and fond of wildlife, and my God, he's a rugby player too.
You're a fan.
Yeah. February 2021, he was recommended by the Supreme Court Collegium for elevation as a judge of the Karnataka High Court. However, after years in past, on February 4, 2022, Aditya Sondhi decided that 1 year was more than a reasonable time to have waited, and he withdrew his consent. I don't want to take much of his time. Aditya Sondhi is 3 years junior to our dear Santosh Matthew, and age-wise I am also junior to Santosh Matthew, but he's using hair dye and we don't. Sir, we'll sit there and watch you enjoy the lecture, his knowledge and wisdom. Sir, floor is all yours.
Thank you, Shri Vijayan, Justice Kuni Krishnan, Shri Anand, Shri Peter, Shri Aditya, who's taken very good care of me. Thank you very much for this warm and generous invitation to this outstanding High Court. I've had the pleasure of appearing here a few times, and now I'm deeply honored to be speaking to you on a topic which is, I believe, more current because of the recent EWS judgment, and relevant as well, as I will try and demonstrate in the course of the evening. I must thank Advocate Ashik for his efforts in arranging this lecture today, and thank you once again for having me. One objection on principles of natural justice: Santosh is not here, so the quip that you made at his back, he may complain, is in violation of natural justice. I wish he was here, my friend. Friends, I'm going to speak to you today about the future of the basic structure doctrine. And as I foresee challenges and threats to it in the years to come. And when I say years to come, in my mind, I don't feel it is many years to come. I feel in the next couple of years, we may see scenarios emerging where this basic structure doctrine is going to be looked at once again by the Supreme Court, by us as the legal community, and by the country at large. Before I go into the potential prognosis for the future, to understand the future of the basic structure doctrine, we must first try and understand its past. And I will spend a little bit of time giving you a snapshot of this. Now, some constitutions globally have what they call eternity clauses, which are clauses that remain non-derogable for all times to come. The German constitution, I believe, has one such provision with regard to dignity. Now, our constitution does not per se, in its original text, contain any provision that is non-derogable or cannot be amended. Equally, Article 368, as it stood prior to the 1971 amendment, referred to the procedure for amendment and not the power. And I think that is important for us to understand how the constitution makers perhaps saw this process of amendment of the constitution. The very fact that Article 368 referred to the procedure for amendment suggests that perhaps it was not really meant to be a substantive power. That of course takes us into other vexed questions as to where that power then emerges from. Surely in a vibrant democracy like ours, we can't say that we have a rigid constitution that can never be amended. But the Supreme Court had multiple occasions to deal with the power of the Parliament, of the government, to amend the constitution, and as to how far that could go. Of course, we all know the celebrated Keshwanand Bharati case, which arose from a petitioner in Kerala, in a sense settled that position by virtue of a 7-6 judgment. Why I say 7-6 is that while studying some of the crucial judgments on the principle of amendment of the Constitution, on the basic structure doctrine, I find that invariably they are not unanimous. Invariably these judgments are 3:4, 6:5. Golaknath was a 6:5 judgment. The recent EWS judgment, which came out a few days ago, was a 3:2 judgment. And I only park this thought to return to it a little later to say that in our structure of constitutionalism, our system of constitutionalism, the interpretation of basic structure is a judge-made doctrine. It is a doctrine dependent upon judicial interpretation and judicial ideology. It is prone to differences of view and perspective and paradigm, and is therefore very much in a state of flux. We can say today that the doctrine of basic structure in a sense is here to stay. By that I mean, today the status quo, to use a lawyerly expression, the status quo today is that Parliament cannot offend the basic structure. Parliament can amend the constitution but cannot offend the basic structure. But whether this status quo will continue, if so in what form, I believe is something we need to deliberate upon, and we shall do so today in the course of this conversation. I look forward to questions from my friends as well after my submissions to you. I had recently, friends, delivered a lecture on the Constitution and the idea of India just a few days ago. And while developing a thought that the Constitution is inherently linked to our understanding, our identity and our idea of being Indians, I had to highlight the fact that the Constitution is not necessarily what the letter of the Constitution says, but it is more what the courts interpret it to be. And we are now so far in that jurisprudence that sometimes the letter of the Constitution may not even matter. Some of the most central themes relating to our constitutionalism are judge-made doctrines. The basic structure doctrine itself is a judicial construct. The collegium concept is a judicial construct. The many facets of the right to life, dignity, autonomy, privacy, etc. are all judicial constructs. Federalism, which has been interpreted to be a facet of the basic structure of the Constitution, does not find reference in the preamble, but it's something the courts have developed, and perhaps no state better than the state of Kerala knows how serious the concept of federalism is. It is one of the few states where you have a government that is not the same government at the center. Therefore, the play and the friction is greater. Your governor is in the news regularly. We read about him in Bangalore on a daily basis. And this friction, if you will, or conflict, constitutional conflict, which leads to the concept of federalism, is again, as a basic structure concept, a judge-made doctrine. And we have seen this position develop over the years. Traditionally, the courts did not read limitations into the powers of Parliament to amend. Courts felt you could do what you want because this was the discretion of a Parliament, if you will. Shankari Prasad's case, thereafter Sajjan Singh's case. Sajjan Singh was a 3:2 judgment again. And the minority view in Sajjan Singh, especially Justice Mudholkar's view, in many ways later on went on to become the majority view in Keshavanand Bharati. It also tells you something about the importance of judicial dissent and how dissent at one era can become the prevalent majority acceptable view in another. And I think therefore there is a lot of scholarship and study that is required to go into the history of dissent in the Indian Supreme Court and the High Courts itself. Justice Rohinton Nariman has in fact published extensively on that. But the interesting thing that I want to tell you, friends, is that Justice Mudholkar, while writing for the minority, borrowed from a principle of the basic feature test which was applied by the Supreme Court of Pakistan. We may not like this, especially on a day when we've lost to England and Pakistan is in the final, but we have to give credit where it's due. And it's, I think, Fazlul Chowdhury's case, where the Pakistan Supreme Court dealt with this concept of basic features. It didn't quite use the phrase basic structure, but the concept is the same. While dealing with the power to amend or to understand a constitution, the Pakistan Supreme Court in this judgment, in fact, discussed the idea of the basic features of a constitution, which then Justice Mudholkar referred to, and with the march of the law, in fact, has gone on to become a doctrine, as I said, that is here to stay, at least for now. The interesting thing is that at this point the Supreme Court recognized the power, as I said, to amend to be in some ways unfettered. It is with Golaknath's case that the position stood altered. Golaknath in fact read Article 368 to say, amongst other things, that it was largely procedural. The power to legislate had to be traced to other parts of the Constitution like Article 245, 246, etc. And that 368 was not a carte blanche for the government to do as it pleases. That led then to the 1971 amendment, the 24th amendment to the Constitution, whereby 368's language was completely changed. And if you read 368 now, it says that it is the power to amend. And not just the power to amend, it is the constituent power. I believe those words have some meaning. By bringing in that amendment, by treating it as a constituent power, Parliament in fact sought to bring back to itself the power that perhaps the Constituent Assembly exercised at the time of drafting. And this, I think, is important because, at least for political theorists, the debate is out as to who is sovereign in the country. Is it Parliament that is sovereign? Is it the Constitution that is sovereign? Is it that the Constituent Assembly has primacy over Parliament? These are not easy theoretical questions to answer. But the usage of the word or the words constituent power obviously sought to suggest that Parliament wanted to reconstruct or revert to itself the powers of the Constituent Assembly, which really means a power to rewrite the Constitution if it wants. We know that that position was challenged in the Supreme Court. Minerva Mills case, the Supreme Court read down many provisions of 368, including the provisions which barred judicial review, and of course the centerpiece of the jurisprudence, which is Keshwanand Bharti's case, which led to the I was going to say the settled position, but again we must bear in mind it was a 7:6 judgment. Of course it binds and it holds today, but it does suggest to you that on the largest bench that the Indian Supreme Court has had thus far, which is of 13 judges, it was a very, very narrow majority. And it is perhaps for this judgment in some ways that Justice Khanna is celebrated, because many feel it was his judgment that ultimately tilted the balance in favor of the petitioners and building in this concept of the identity of the Constitution. That is to say, yes, of course you have the power to amend, but the power to amend does not include the power to destroy. You cannot obfuscate or deface the Constitution or rewrite the Constitution in the name or in the guise of amendment. And that, I think, is a very fine principle that came to be laid down. Mr. Palkiwala's contribution to that development is crucial. People have compared it to a sutra as a very simplistic but deep principle, which is to say the power to amend does not include the power to destroy. If you see it that way, it becomes easier then to test amendments and to see what their intended object is. For example, the Constitution has been amended to provide for the right to education. Article 21A, that is an amendment. I don't think anyone can say that destroys the Constitution. It in fact furthers it. Article 371J, which is a constitutional amendment which is special to our state, to the state of Karnataka from where I belong, because that recognizes special rights of people belonging to the Hyderabad Karnataka region. Now that is a constitutional amendment, but I don't think one would be able to say that it defaces or destroys the constitutional principles. If anything, you would like to believe that it furthers it. But things are not always that simple. And I think the progression has been very interesting. As I told you, Bomai's case, secularism was interpreted to be part of the basic structure. Now please remember, secularism was never even originally part of the preamble. It was introduced by amendment. So it's very interesting that the Supreme Court found the concept of secularism to be part of our basic structure when it did not even exist in the original text. But that tells you the manner in which courts have been building upon the Keshwanand Bharati jurisprudence to expand the concept of basic structure and to create these checks and balances to make sure that parliament does not run amok. In fact, Professor Upendra Bakshi had said, if you don't have brakes like basic structure, then this car is just going to plow into into ongoing traffic. And that's a nice analogy to say that the basic structure doctrine is a check or a brake on this power. But perhaps the sharpest, in my opinion, the sharpest application of this basic structure doctrine that has taken place was in the NJAC's case. And I say this because NJAC, the amendment to the constitution to provide for a new commission for judicial appointments, in some ways struck at the very heart of the constitution. We may differ on whether you need an NJAC or not, whether you need a collegium or not, do you need the collegium in the present avatar or not, that's a slightly separate debate. But the NJAC came at a time when we had also, along with the basic structure principles, progressed on one other track, which was the method of judicial appointments in India. As I said, the word collegium finds no mention in the constitution. It came to be developed over years and over judgments, Scora 1, Scora 2, and moved from primacy of the executive to the primacy of the Chief Justice, a check on the power of the Chief Justice by creating a collegium, and ultimately a collegium system which one came to accept as the best available alternative because one had seen the abuses of executive power during and after emergency. I mentioned to you Justice H.R. Khanna, we all know that he was passed over and had to step down. We know of the 3 other supersessions that took place in the Supreme Court and what happened across the high courts during those times. But in the NJAC case, the Supreme Court was now required to consider 2 important things. I think the first aspect was easier, which is whether judicial independence is part of the basic structure. I think that's a given. We have to, whether one may have the deepest faith in our system or not, I think in principle one has to agree that judicial independence is indeed part of the basic structure. There is no other way a vibrant constitutional democracy like ours can function. But the second was the more vexed question, which is whether the collegium is part of the basic structure. And I think that is an interesting question that NJAC dealt with. It was a 4:1, again as I told you, not a unanimous judgment, but a slightly bigger majority. Justice Chalmeshwar dissented. But in the course of that judgment, the Supreme Court found that the NJAC as a construct did not just violate judicial independence, but it also violated the concept of a collegium. And therefore, the collegium, for all purposes, is today read to be a part of the basic structure of our constitution. And I will tell you how this ties in to the future of this doctrine shortly. This is, I think, a very interesting case study by itself, because rarely will we find instances where 2 judge-made doctrines are being applied so extensively. A constitutional scholar from, say, the UK or even the US may struggle to understand these concepts because they will say, where is basic structure and where is collegium even mentioned in your constitution? But we've gone so far, and I think that is to the credit of our system, that we've developed these principles and this jurisprudence where we are not bound by the letter of the constitution itself. It's not read like an ordinary statute. It is read as a living and a developing document. And the 2 most central themes of judicial independence, collegium, and basic structure are both constructs of the judiciary. As much as I have to say that credit is to be given for this development, I must also say that this is perhaps where the risk or the threat lies to the future of the basic structure doctrine. Because the reason is that judicial views, as we know, are prone to change. They are prone to change, they are prone to dissent, they are prone to being overruled, reviewed, etc. And there is every likelihood, therefore, that this concept of basic structure in the near future is going to be looked at far more closely. The EWS judgment, I have not fully studied it yet, but whatever I have read of it makes it very clear that on a 3:2 majority, a constitution bench of the Supreme Court has diametrically differed on understanding the basic structure of the constitution. Now we may say the basic structure of the constitution is crucial, but we must also then recognize as to who defines what that basic structure is. It is the bench. And therein is the scope for dissent, the scope for disagreement, the scope for divergence on something so conceptual. Whatever I saw of the EWS judgment, there are fundamental position differences between the majority and the minority. One, the majority view is that yes, equality is indeed part of the basic structure, but the EWS reservation by itself does not violate it. It does not matter if EWS is not provided to what we call SEBCs or the socially and economically backward classes. In the same breath, the minority view, and this is a rare instance where the Chief Justice is part of the minority, I don't know of many such precedents, the minority view authored by Justice Bhatt holds that the exclusion of SEBCs from a category of reservation such as this by itself is unconstitutional and violates the basic structure of equality for the reason that the concept of reservation is inherent in equality. Please see the ideological differences and the positions that are there. I believe it's healthy also for a democracy to have such different views. But let me reiterate, that is where the threat or the risk to the basic structure doctrine is. How do we see these concepts? And these are very important concepts. There are larger questions to be asked. Is it really meant for the courts to decide what the basic structure is? I personally feel there are no better alternatives. I have still a greater comfort with the courts telling you what the basic structure is than somebody else with a vested interest. But that is again a separate debate. But just coming back to this, the majority view in the EWS judgment also said that the concept of reservation should be done away with and that we ought to quickly move to being a casteless, classless society. Now yes, that is an ideal outcome. One is aware that reservations were never meant to be in place forever. That said, we need to also socially, economically, politically, as Dr. Ambedkar foresaw, question whether we in India have reached a stage where reservations have already fully served their purpose. But here is a conceptual difference. One part of the bench feels reservations themselves must go, and EWS as a standalone provision of reservation for the forward caste is perfectly valid. And you have another faction of the bench or another part of the bench which feels that reservations are inherent to the concept of equality. You cannot have economic reservation without including the SEBCs. I don't want to digress into this judgment alone because that I think is a separate case study. But I want to use it as a current and I believe a very relevant example to emphasize the point that I'm trying to make, which is that the concept of basic structure is not set in stone. Maybe it is set in stone today that the basic structure cannot be offended. Fine, Keshwanand Bharti, Minerva Mills, Bomai, etc. But what that basic structure is, I think is a question at large. It is something that is going to be very much, in my view, prone to change and interpretation in the years, if not the months to come. And if I can make that prediction based on what I have been observing of late, and this comes largely from the statements which the Union Law Minister has made almost on a weekly basis, which is to take pot shots at the collegium system, which is to say the collegium system is not necessarily working. Judges say that themselves, that the concept of the executive not having a say in the appointments, the politics in judicial appointments, etc. You must have noticed this trend. These statements are being made regularly. I don't think they're being made casually. A law minister would say that with all responsibility, I feel. I feel that is being said to also build public opinion, to try and push for the return of the NJAC in a new avatar. And I won't be surprised if sooner rather than later one finds an amendment to the constitution where NJAC version 2 is introduced. And when NJAC version 2 is introduced, I have no doubt that it will be challenged in court. And it will be challenged in court on the obvious grounds, which is that it violates the basic structure and that it is violative of the judgment in NJSC 1. This is where perhaps I foresee that the government would then like to push for a review of Keshwanand Bharti itself. I don't think that's too outrageous to presume. The government may very well like to ask the Supreme Court to constitute a bench of 15 judges to relook at Keshwanand and to decide whether this basic structure doctrine at all should stay. Now, how that goes, nobody knows. Maybe I'm being bold or hasty in saying this, but it's quite probable. And let us at least test it theoretically. Whether it happens or not is besides the point. Should that happen, the central determination to be made in that case will not be whether NJSC is constitutional. The central determination would be whether basic structure is a given concept or not. And if that happens, let us assume it goes to a bench of 15 judges, the outcome could be anything. Because as I've already demonstrated to you empirically, in most of these cases, you do not have unanimous views. And the perception of the very concept of basic structure itself may differ. And that, friends, to me, is going to question or risk the future of the basic structure doctrine. As much as it is a very, I think, unique, beautiful illustration of a judicial constitutional construct, it has been followed and applied worldwide. We should be proud of this. I've said this many times, that there was a time, I don't know if people still say it, but not in the recent, till the recent past, people would say that the Communist Party of India, the President of the United States and the Supreme Court of India are the three most powerful institutions in the world. Now, I don't know whether the President of the US can still, as an institution, be counted in this category. The Communist Party seems to be going from strength to strength. Is the Supreme Court of India holding that all-powerful position today or not? I leave to your judgment. But the point is, that status that it enjoyed or enjoys today is not an accident. That has come from post-emergency Keshwanand Bharti and then post-emergency 30 to 40 years of developing the jurisprudence that has been followed worldwide. Bangladesh has a basic structure doctrine. Malaysia has a basic structure doctrine. There are many jurisdictions that have borrowed legal principles from us, not just on basic structure, but on environmental law, on human rights, on civil rights, etc. That is the preeminent position of the jurisprudence of the Indian courts in the world. But that said, should this challenge arise, I believe there will be serious and deep-rooted questions that will be asked of this concept of basic structure, of the concept of the collegium itself. And that, friends, will take us, I feel, into probably new jurisprudence in time to come. Nobody can predict where that will go. But one thing is certain, that it will be a choppy ride. It's not going to be a given one way or the other, because as has been the case historically, and more so now, I think we are getting, I won't necessarily say polarized, but we take our positions. And today positions are made known and applied. And judges don't, again, the honorable judges will bear me out here, that judges don't decide cases in a vacuum. It is a decision made basis the assistance and inputs provided by the bar. And that then shifts the focus, friends, to the role that the bar plays in this process. But those are going to be interesting times. But it will still, I believe, make us reflect once again on what alternatives do we have. It's one thing to say that we want to revert to a pre-Keshwanand Bharti, pre-Golaknath era, where Parliament could amend as it wills, it could rewrite a constitution, it could lead us, I hope not, but to the jurisprudence of ADM Jabalpur, where fundamental rights were treated as fully suspended with no access to justice or to the courts. Those are the parts that we should not be proud of. That is the jurisprudence. I'm not saying this, the Supreme Court itself has said it. While overruling Jabalpur, the Supreme Court has said that, if not in literal words, but at least in allegory, that those are black marks in our constitutional history. But that debate is going to be out. And that debate, friends, is not a theoretical debate. I don't think the EWS judgment or the NJSE judgment or any of these judgments which pertain so closely to our profession, to our society, to our role as not just as lawyers but as citizens, I don't think those judgments are just to be cited or looked at theoretically or to be put away, because some of those judgments are so bulky that lawyers, we find it difficult to even read a judgment fully. We would much rather put it to the side and let somebody else write a 500-word review of it, and you read that and you think you've read the judgment. I've made that mistake myself sometimes. But this is not just academic. This is going to tie in with the idea of India. I started by saying that at least I belong to that school of thought that believes that the Constitution defines the idea of India. Individuals don't, governments don't, states don't, media does not, powerful elite do not. It is a constitution that caters to all and caters especially to those who need justice, those who come to the courts. If that is the idea, then this upcoming possible challenge to the idea of basic structure, I think, is going to tie back very closely to who we are as Indians. What is our role in society? What is, more importantly then, our role at the bar? How independent are we? It's convenient to critique or talk about judicial independence, but we also then have to look at our independence. The president of the bar is here, and I'm sure you will share this. Bar associations across the country are consciously talking about this, and as they should. They have been at the forefront of standing up against any form of autocracy. Even during the emergency period, it was the legal community to a large extent that stood tall. Even the media did not. Mr. Advani, I remember, had said that when the media was asked to walk, it crawled. But the few bold judges from the Karnataka High Court, Justice Chandrasekhar, right, Justice Chagla, and who later appeared, in fact, in Karnataka in the emergency period, these were the people who were the torchbearers of fearless advocacy, fearless decision making at the risk of their own careers, sometimes at the risk of their own safety. How many judges and lawyers do we know of who were incarcerated? When I say judges, I mean lawyers who went on to become judges. Justice Santosh Hegde's father, etc. I don't want to digress into that. But that brings me back to the point that we cannot discuss the concept of basic structure and its future without then concluding by discussing the concept of judicial independence itself. Whether judicial independence is achieved through a collegium system or an improved system is besides the point. But today, I'm sure you will share my view that judicial independence is not seen in the same unblemished way as it used to be even 7, 8, 10 years ago. Why that has happened, who is responsible, again, a different debate. But if we have come to that stage, then we have to then acknowledge the truth. As they say, we have to then smell the coffee. That it is this same process that is going to lead to decisions to be made on what is the basic structure. And the basic structure is the heart of the Constitution. And as I said, to me at least, the Constitution is at the heart of being Indian. And therefore this is more serious, more real than some would like to believe. I don't want to get into extraneous conversations around these aspects of independence, etc. But we know that there are challenges galore within the system. We know of the conference that 4 senior judges of the Supreme Court called. We know what they had to say. We know of senior judges who have stayed away from collegium meetings in protest. Why? And that is giving then greater scope for the executive, for the media, for social media, for bloggers, for people sometimes with an agenda to take pot shots. And it's fine, you will take pot shots, You will dilute the prestige and credibility of the system, but then what alternative are we moving towards? The President mentioned the topic of my PhD, which was a comparative study between India and Pakistan, though it was more on civil-military relations. But one conclusion I came to, which I think is unchallenged, is that India is India and Pakistan is not India because of the role our courts have played. Obviously, the military has eaten into the heart of politics in Pakistan, even with the recent tenure that Imran Khan had, etc. The military is always there to stay. But how did that come to be? And it came to be because Pakistan had a constitution later than us, and because Pakistan did not have the jurisprudence that we developed over these years. As much as I said, the basic features concept may have been used in a judgment of the Pakistan Supreme Court, but I don't think it has been applied anywhere near as it has been done in Indian law. If you look at the list of what the basic structure is today, it's an all-expansive list. In fact, some people may say the entire constitution is basic structure. Everything is part of the basic structure. You know that list. Judicial review, judicial independence, preamble, federalism, secularism, they're all part, fundamental rights, equality. They are all part of the basic structure. So that is, and this is, friends, a judicial construct, which has therefore the attributes of a very interesting and evolving system of a constitution, but it equally has, I think, the risks and the vulnerabilities, because it is ultimately judge-made. And what the future then of the basic structure doctrine in India will be, will depend necessarily on how we appoint our judges, how we promote and elevate our judges, how independent our judiciary remains, what role the bar plays in that process, how independent the bar is, how strongly the bar supports and participates and engages with this process. I think, friends, that is where the future of the basic structure lies. I would like to end on an optimistic note that I believe that the very fact that we are having this conversation this evening, we have such a strong and engaged turnout, suggests to me that we as Indians are engaged with this idea. We are committed to this idea. But how it plays out, I think, will be anybody's guess. I thank you very much for this invitation.
Thank you, sir, for the great session. If any of you have any queries too, you may come forward. Yes.
Hello. Sir, I would like to ask you a question. As you know that there is a tug of war between the Chief Minister of Kerala and the Governor. My question is that whether the Governor has the power to drop or terminate a minister on the ground of pleasure without the recommendation of the Chief Minister. Second question is that twice the Assembly has passed a bill and sent to the Governor for his assignment signature, but he kept it without giving his signature. How many times? Not how many times. How many months or he can keep that bill without giving his signature?
Both questions don't relate to my topic, but
you are from Supreme Court. The Kerala government has given 40 lakh rupees to an advocate in Supreme Court for this answer. 47 rupees. That is why yes. If you answer,
maybe that gentleman should answer it. But suffice it to say, I don't think I'll answer both only in principle, sir. I will not answer it in the context of any ongoing dispute, especially some of this is even sub judice. But I do believe the President or the Governor, when the bill returns for the second time, ought to act as expeditiously as possible. There is no time frame set in the Constitution, but it requires a responsible and objective constitutional functionary to act reasonably and expeditiously in larger interest. Your first question, sir, was regarding removal on the principle of pleasure. That pleasure is not absolute. That pleasure has to be exercised based on the aid and advice that is received from the Council of Ministers. I think that position is legally well settled.
If Any of you have any other questions related to the topic?
Sir, I have a small question. Sir, you mentioned, most of your talk, from what I understand, has been about the fact that the basic structure doctrine is not infallible. However, there is a saying that tyranny is the government for people who want to get things done. Therefore, there is a very obvious correlation between common consciousness and how the law works. How else are we supposed to make this reflect with the way the Constitution functions?
Yeah, that's a great question. It has many philosophical undertones to it. Please sit down. See, when you say common consciousness, I think there are multiple common consciousness. There are multiple ideas of India. And as I said, it would be hard for one to point fingers at which is right or wrong. Even when you look at the majority view in EWS, a large fraction of our common consciousness, as you mentioned, will agree with it. And then you look at the minority, and a large common consciousness will agree with that. And the minority of 30 years ago becomes the majority of today. So I don't think it is so simply addressed. Common consciousness in a country as complex and vast as ours can never be one. It is bound to be diverse, it's bound to be different. The only thing one can expect and work towards is to have an honest common consciousness, is to have a sense of informed consciousness. That is the first, I believe, important step. It has to be not a political consciousness, it should not be a motivated consciousness, but it should be a personal and a deeply thought through consciousness. The second question is a structural one. How do judges reflect that common consciousness? I think that is the question to be asked. A lot of people say 3, 5 judges or 7 judges cannot speak for India. But we have to then test what the alternatives are. We need to see whether this is the best available alternative, or do you structurally have a better one? If you don't have a better one, then it brings me to the crux of what I said to you, which is how do you ensure then that this institution that is empowered and vested with the power to decide these larger identity questions acts in the best interests, acts objectively, and acts as per experience and intuition, let us say, of matters of the Constitution. That necessarily then takes you to the appointment process. And if we can purify that, if we can work and debate that, I think the rest will automatically follow, at least for the status quo, till such time you come up with alternatives. It's not that you have brilliant alternatives, sir. You look at the trajectory of the US Supreme Court, for example, Roe versus Wade overruled. They've gone back 50 years. I'm told now that race-based admissions in colleges in the US, that theory is going to be set aside by the Supreme Court. You look at the UK, something like Brexit was never challenged because courts there keep their hands off. You had that one instance where the UK Supreme Court set aside the abrogation of Parliament, the adjournment practically that the Prime Minister brought, and the jurists were up in arms as if the Supreme Court had done something of a game changer. In India, we are so used to the Supreme Court interfering, what we call judicial activism, you would just take those things for granted. So even in what we call, in inverted commas, developed democracies, the role of the Supreme Court actually there is fairly questionable. And therefore we need to finally reflect on what alternative paradigms we have. Are they valid substitutes or not? And if not, how do we then strengthen the existing system?
Any other questions?
So you started being a depressive possibility of the basic structure doctrine itself changing.
Madam Clerk, can you please ask?
The kind of negative prognosis with which you started, that possibly the basic structure doctrine itself might change, and maybe within the next 2 years or a few months down the line. With that, you also spoke about the eternity clauses which are there in places like Germany. So question is, hypothetically, because it's just not possible under the present parliament, what we have or what we probably foresee in the next couple of general elections, despite that, if an eternity clause were to be introduced, would that be a violation of the Constitution's basic doctrines?
Yeah, that's a very interesting question. Look, I think it would come down to what is insulated as that eternity clause. Firstly, in concept, an eternity clause should be contained in the original text, at least principally. But it's an innovation. And as we've done over the years, for example, the whole Schedule 9 insertion, to move legislation to say Schedule 9 and try and completely insulate them from judicial review, is a very interesting construct. It's been read down, Coelho, etc., but it's still there. And how that reads with directive principles, etc., the law is still wide open, I feel. It's not finally settled. And this was not something that was there originally in the text. It's come to be. And it therefore intersects judicial review on the one hand, parliamentary legislation on the other, amendment and so on. So hypothetically, an eternity clause can even come now. What does it contain? What does it seek to preserve for all times to come is the question. And that is where it will be tested. Supposing that happens now, it will be tested on the basis of the jurisprudence we have today. The jurisprudence that we have today, even with all its lacuna, by and large, still leans towards constitutionalism. So if that eternity clause in some way is furthering it, the examples I gave you of amendment, right to education, etc., further it. We've had more than 100 amendments to our constitution. So it's not that amendment is as a concept bad or unwelcome. But I think the devil will be in that detail. What is the eternity clause? And if that is a bona fide exercise in constitutionalism, it may very well be upheld. Why not? But if it is a tactic to somehow get over judicial review, to indirectly dilute the basic structure doctrine, then once again the courts will be right at the center of that process. It will come down to how those benches, those judges, respective judges see those concepts.
Sir, my question is this exclusionary practice in the pretext of this affirmative action, as we have seen in AW's judgment, whether that amounts to violation of this basic structure principle.
So that's a very open-ended question in the sense, if you're asking me in the context of EWS itself, the majority view is there. By a thin majority, the bench is held that it may be exclusionary in a sense, but it's still valid and within the basic structure because it does not overlap and should not overlap with existing reservations. It takes you then into the question whether 50% reservation, Indra Sani, etc., whether those doctrines are also part of the basic structure. And the majority has said no. Majority has said 50% is a cutoff for SEBC. It is not a cutoff for EWS, which is a separate category. So, to that extent, your question is answered by this judgment. The larger question whether affirmative action by itself is exclusionary, I think takes for a far longer conversation. I think it depends on where you stand on the spectrum. I belong to a school of thought which believes that affirmative action is at the heart of our constitution. It's something we borrowed from American constitutionalism, and it is meant to set right historical injustices. How long it should stay, in what form it should stay, etc., are a separate debate. But I believe that those who see equality as absolute and who feel that equality and merit stand by themselves without affirmative action, I think in a way are treating unequals as equal. We know of people who have had 7 generations of manual scavengers. To have a child from that community to compete with somebody who is from 7 generations of professors in itself, I think, is an unequal situation. It is that affirmative action seeks to set right. If it means exclusion of some for the inclusion of others, that's how it works. That is how the South African model works. The South African constitution has developed this very concept of diversity, of equality, to move away from race. In their case, they had a different baggage to get over. But I believe, long answer short, I believe that all of these concepts have to be connected to the realities of our society as we speak. If they belong at that time and they provide for a balm and to equalize injustices, they have a rightful place in our constitution.
I think the questions are over. Now I'd like to invite our Secretary, Advocate K. Anand, to present a memento on behalf of our association as a token of appreciation to Senior Advocate Dr. Aditya Sondhi. We'd also like to, on behalf of the Executive Committee, also like to give a gift. Senior Advocate Aditya Sondhi. Now to the concluding part of the session. Senior Advocate Aditya Sondhi has been kind enough to continue to deliver a lecture despite his busy schedule when the Executive Committee had contacted him. Sir, on behalf of the Executive Committee and each of the members of the association, I'd like to extend my heartfelt gratitude for coming down here and delivering a lecture on this topic, especially for beautifully illustrating the future of the basic structure, going through our past and present constitutional history. Thank you, sir. I'd like to extend my gratitude to the honorable judges who are present here, to the senior advocates and each of the members of our bar for supporting us in all our initiatives. Keep supporting us. Thank you. Thank you very much.
Yes.